Morgan?
Yes.
Oh, I'm sorry, we could not hear you. So I'm handing it over to you, and please, thank you so much for hosting this webinar with us and sharing the information with our schools.
Thank you. So hello, everybody. My name is Morgan Whitlatch. I'm Legal Director at Quality Trust for Individuals with Disabilities, and I'm really excited to be here today to talk about the transfer of rights and decision-making supports that are available for adults with disabilities in DC, including students in special education who have reached the age of 18. What topics are we going to cover today? Well, we're going to talk about what happens when a student with a disability turns 18, what adult guardianship is in DC, and adult guardianship is one of those things that varies by state law, what families and IEP teams should think about and why they should think about other options first, and what those other options look like. So in DC, under current DC law, a person automatically gets to make his or her own decisions upon turning 18 years old. Patient has a 504 plan, they are considered to be a legal adult. And so that means they get to make their own school decisions. What it's really called is transfer of rights, and that's the term that the Office of State Superintendent of Education uses to describe this transfer of rights from the parent to the student when the student turns 18. And it means that the adult student is going to be given all of the written notices about meetings and any changes that the school wants to make to the child's services or placement. It's the student who would be consenting to new evaluations. It's the student who would be agreeing or not agreeing with their IEP. And it would be the student that would be the one filing a complaint or request for hearing if they disagree with the school's decision about their services or placement. So that is what we mean when we say transfer of rights. So what is guardianship for adults? Guardianship, there's a lot of myths out there about what adult guardianship is. And I can imagine that when we're talking about the transition and transfer of rights, questions of families come up about what guardianship is. The first to remember is parents do not automatically become guardians of their adult children with disabilities. Even though they've been supporting those children all their lives, when the students turn 18, they are the legal adults. So the parents don't automatically become their guardians. To have guardianship, the parents would need to go through a court process and get a court order. So when I frequently get calls from parents who say, my child is 18, I need help with something, I'm the guardian, I ask them, have you been to court? And if they say no, then I know they're likely not the legal guardian of their adult child with a disability. So it does involve going to court, it does involve getting a court order, and it's a different process than getting guardianship over a minor child. For example, some grandparents have minor guardianship, it's called, over their grandchildren to support them when they're minors. And when they turn to be 18, that minor guardianship order isn't in effect anymore. And there's a different process that applies to adults, which is what we're talking about, which is adult guardianship in the district. Guardianship can vary in scope. It can be limited in terms of time, in terms of scope, and in terms of permanency. And that's something to remember as well. Just because a parent has gone to guardianship court doesn't mean that they have automatically have control over all of the decisions of the adult student. In DC, the guardianship process requires a petition in the DC Superior Court. Guardianship must be as limited as possible, so we really do encourage families to really explore if they're thinking guardianship is the answer for them, despite exploring alternatives, really try to narrow that guardianship to just those things that are absolutely necessary. And there's going to be a court hearing. This is not something that's just about pushing paper around or filing paper. There's going to be a court hearing. It's a formal court process. There's going to be a judge. And there's also going to be a lot of other people that the judge can appoint to be involved in the case. And I always think it's important for parents' eyes on this issue to be open when they realize what it really means when you become a guardian is you're inviting the court into your life and it's going to be a court proceeding. So this lists all the people, this slide lists all the people that the judge can appoint, including an attorney to represent the person with a disability, a guardian ad litem, which is another attorney that really helps the person with a disability figure out what's in their best interest, a visitor, which is a social worker, usually, who looks at, investigates the household, the parents, interviews people to make recommendations to the court, and an examiner. And an examiner is someone who is usually a psychologist or a clinical social worker that assesses the capacity of the person with a disability. And after getting all of this kind of information and after receiving these investigations from the visitor, the judge is going to make a decision. The judge is going to decide, one, if the person is incapacitated, meaning that the person can't make certain kinds of decisions, and then two, whether or not guardianship is necessary. And what does necessary mean? Well, it's here that really comes into play the different tools other than guardianship that are less restrictive that we're going to be talking about. To be necessary, those tools would not be able to be utilized in the case. And so this also should encourage families to explore those alternatives first, because that's what the law is implying. And if it's yes to both of these questions, if the person is incapacitated and the guardianship is necessary, then the judge makes a decision about who that guardian will be. And it's important for families to understand that the judge doesn't always appoint the petitioner or the person who's filing the petition, the parent, to be the guardian. There is some preference for doing so, of course, but sometimes disagreements can come up during the course of the proceeding. There can be parents who are, for example, divorced and fighting over who should be the guardian, where the judge can throw up his or her hands and say he's going to appoint a professional guardian from a pool of guardians. Sometimes the visitor's investigation has turned up certain kinds of concerning aspects, like maybe a concerning criminal record or something for the person who's applying for guardianship, and they can raise that to the court, and that can also be a concern for the judge in appointing who the guardian will be. And then once the guardian gets the piece of paper, it's important to realize that guardianship is more than that particular piece of paper. There are ongoing responsibilities that the guardian is going to have. The guardian's authority is going to be limited by the order in DC law. There are certain decisions that a guardian cannot make, like really serious decisions such as sterilization and other and shock therapy and those kinds of adverse stimuli decisions that a guardian can't make without going back to the judge to ask for specific authority. The guardian has a lot of responsibilities, like submitting written reports twice a year, and this is one that can be very intimidating for families, because if you missed one of those kinds of reports, you can be called back into court to show cause why you should continue to be the guardian since you're not filing your 6-month report. The guardian can also be required to come to the court for more hearings, and also to make decisions on behalf of the person using a substituted judgment standard, which basically means that the guardian is sitting in the shoes of the person with a disability and making decisions that the person would want if they could make those decisions, not decisions that are only based upon their child's best interest. Also, they're supposed to include the person in the decision-making process. DC's law really has great language that talks about how guardians are supposed to support the person in being able to regain capacity and be able to exercise decision-making ability, even when there is a guardian. So why do families sometimes think about guardianship? I get a lot of calls from people, from families saying that the school told them to get guardianship and them not being aware that there are other alternatives that may be able to be used. And they can be worried, for example, that they may not be invited to IEP meetings when their child turns 18 or get information about the school because, educational information is confidential. How will they be able to have access to that once the student has the rights that the parent once had? And even be part of the child's school planning. So there are myths out there that parents are somehow cut out of the process when their child turns 18. And these are myths that we all need to work together to get rid of. Okay, because there are regulations that require parents to continue to get notices of IEP meetings, and there are other ways parents can continue to be involved in the educational decisions of the student without getting guardianship, and we're going to talk more about those too. There can also be other reasons that parents seek guardianship, for example, health care or finances, and we'll briefly touch on those too, but I'm focused today's presentation really on the educational alternatives to guardianship. We really encourage families to think about other options first because it's important to realize that guardianship, although it's intended to be a protection, does that kind of protection by taking away some of a young person's rights and to make important decisions about their lives. And we have to remember that what stage transition-age youth are at. They're just at the cusp of adulthood, okay? They're just, for the first time, being able to make some kinds of decisions if they haven't been involved in their decision-making previously. And so to take away their rights at that time really ignores the fact that they can grow and build capacity over the time by practicing decision-making. I always say decision-making is a muscle, particularly for students with disabilities. If you haven't had a chance to exercise that muscle and be able to have a chance to make decisions, be them small or big, you don't know yet whether or not the person has the capacity they need to make decisions. And so let's not too early take away those rights. I mean, let's think about each of us. What kind of decisions we made in our lives? I know I didn't make great decisions when I turned 18. And so, fortunately, I was allowed to practice my decision-making ability and have it be able to grow over time. So I hope these days I make better decisions than I did when I was 18. The court is going to become part of the guardian's life going forward, and I think that's important to realize. The guardian's authority is really the court's authority. And so the court is going to be involved until the guardianship is terminated, and it won't be terminated unless someone shows the court that the person has regained capacity. So for as long as the person's life, potentially, a court can be involved in it if the person is under guardianship. And the other thing is not to take too lightly is that guardianship really can change relationships. I get a lot of calls from people who are under guardianship who are very unhappy with the actions of their guardian. They're feeling as though they're not being allowed to make choices that are really important to them in their lives, like where they want to live, who they want to socialize with, how they want to spend their money. And these are really important decisions. And so it can change the relationships that exist from a parental relationship to an even more kind of controlling relationship for someone who knows that they're an adult, who knows that they're 18, and yet cannot exercise their choices if they're not being supported properly to do so within the guardianship. Guardianship can also take time and cost money, and that's something important to realize. The court does not automatically appoint an attorney for the parent if they were to file a petition for guardianship, even though the judge is appointing a variety of different other people potentially to be involved in the court proceeding, including an attorney for the adult with the disability. They're not going to be appointing an attorney for the petitioner, and so it can take time. It's a court process, and it can cost money, and that's something to think about too. And as I said before, and I will emphasize again, we really can't think of decision-making as a black and white concept. It's a learned skill. People need an opportunity to practice. People might be able to make some decisions and not others. People might be able to make some decisions at some times and not others. And so we really need to allow young people, particularly, to have the opportunity to exercise decision-making abilities so that they can lead a more self-determined life. We encourage families to explore alternatives first. And these are some kind of questions for parents to be thinking about and teams to be thinking about when they're trying to find the right kind of support. What is the decision that needs to be made? What's the risk involved? How could you undo the decision? Has the person ever had a chance to make that decision before? And is the decision likely to be challenged? And so you compare different kinds of decisions to others. I think actually decisions in the educational realm is a great opportunity for young people to be able to exercise their decision-making ability because they usually do not involve life or death, for example, like open heart surgery. They're talking about education, and you actually are, by definition, when you're in special education, involved in a supportive IEP team relationship. So that can be your circle of support, and you can learn how to try to exercise your ability to make decisions in a safe environment. So we really want people to ask themselves, what's the least restrictive support that might work for this circumstance, and to really break apart what decisions we're talking about. So when a parent calls me and says, I need to get guardianship, I always ask them first why. And then we pick it apart to see if that's really necessary. Okay, sometimes the concerns parents have can't be solved by guardianship. For example, sometimes parents call me and say, I'm really concerned that my child's going to be involved in the criminal justice system. Well, guardianship doesn't stop somebody from being arrested or going to jail. And so that's not really the solution they're looking for. Sometimes people say to me, I want to get guardianship because my child I'm worried they're going to exit themselves out of school when they turn 18. Well, is guardianship really going to help get that child out of the house to school? No. Is the guardian going to drag the child to school to actually get them there? No, you're going to have to get buy-in from the student to be able to really look at the problem. Why doesn't the student want to go to school anymore? What are the student's dreams? And looking at that instead of thinking it's about taking away that student's rights to make a decision that the parent might think is the best one. So as I said, capacity and competence are not black and white concepts. There are many gradations. People can make some decisions and not others, and at certain times and not others. And this is true. We need to think about capacity as not just being an issue of, cognitive disabilities or intellectual disabilities. It can also be mental health disabilities and other kinds of disabilities as well. And particularly with mental health disabilities, that can be very variable in terms of what the person's state of mind is in making decisions. And they might be able to make decisions best at certain times and not others. Similarly, some decisions require less capacity to make than others. I always use the example of, in a flu shot. A flu shot and the risks and benefits of a flu shot and weighing those risks and benefits is a very different kind of conversation than if you are talking about open heart surgery. So someone might be able to consent to a flu shot with support, but not to open heart surgery. So I think we really need to think of gradations in terms of decisions when we talk about decision making for people with disabilities. So what are other options to guardianship that can be used for decisions in school for transition-age youth who have hit 18? Well, there's supported decision-making, which we're going to talk about, educational powers of attorney, and I'm going to talk to you about a new process that's coming soon. So it's not, OSSI hasn't finalized its rules on it yet, but I want you to be aware that it's coming, since those rules are supposed to be finalized by July 1st. So what is supported decision-making? There's a technical definition of what supported decision-making is, and it's up here on my slide. It supports and services that help an adult with a disability make his or her own decisions by using family, friends, members, professionals, other people to help understand those issues, ask questions, have all that legal mumbo-jumbo or school mumbo-jumbo translated into plain language, and then to communicate those decisions to others. So that's what supported decision-making is in the technical sense. But in the practical sense, it's what you and I do every day. Okay, when I have to make a healthcare decision, for example, and I'm confused by what the doctor is telling me, I turn to my sister. Now, my sister's a doctor, but that's not the only reason I turn to her. I turn to her because I trust her and I know she knows me really well. And she knows the way that it's best to communicate with me about things. And we talk through the issue. So she helps me weigh the risks and benefits and helps translate those terms that the doctor might be using so that I can understand them and make a decision for myself. Okay, and when I do that, I'm considered to be a wise person. Okay, I'm using my support network so I understand the problems and the problems that I face so I can make choices to address those problems. So unfortunately, sometimes when people with disabilities seek help in making decisions, there gets to be the assumption that they can't make any decisions at all. And we need to break that down. It's why we've had to come up with a fancy term for supported decision-making so that we have something we can point to say, no, students and young adults and adults with disabilities, their capacity should not be judged in a vacuum. They should be able to use the support networks around them to make decisions just like everybody else does every day. And so that's what supported decision-making is and the concept. Supported decision-making is already in DC law. Okay, the recent special education reform legislation that went into effect in March of 2015 specifically recognized that students can use support networks when they make their decisions upon reaching 18. And also, the Office of State Superintendent of Education has issued proposed regulations, so they're not final yet, but they have to be by July 1st, so they're coming, on transfer of rights. And those include an express definition of supported decision-making and an encouragement to use supported decision-making before resorting to more restrictive alternatives. DCPS, or DC Public Schools, is already implementing supported decision-making in its policy and practice, even without these OSSI rules. And it's because supported decision-making really needs to be regarded as accommodation, okay? Schools are already covered by the American with Disabilities Act. They're already covered by Section 504 of the Rehabilitation Act. And that requires them to accommodate the student with a disability. And that can include allowing them access to the supports they need to be able to make their own decisions. It can mean allowing them the time they need to be able to make decisions and have their questions answered. So it's already in law. Well, it's nice to have a term we can point to in the regulations about supported decision making. That's not required because we already are required to accommodate people with disabilities in aspects of their life. It also makes sense. There have been study after study that have showed that people who have greater self-determination, which means that you have an opportunity to be a causal agent in your own life, an actor instead of being acted upon, have better life outcomes. They have more independence. They're more integrated in their community. They're healthier. They're better able to recognize and resist abuse. When people are denied self-determination, on the other hand, we've heard concepts of learned helplessness. They can feel helpless, hopeless, and self-critical and have low self-esteem, and it can decrease their ability to function. They can have decreased life outcomes. Overbroad and undue guardianship has been shown to have a negative impact on physical and mental health, ability to function, and reports of how people feel about themselves. This is particularly true in the student context. Students who have self-determination skills studies have shown are more likely to be able to make that successful transition to adulthood, which we know can always be a challenge, including improved education, employment, and independent living outcomes. Really, promoting self-determination has been recognized as a best practice in special education, and so schools should be focusing on trying to improve students' abilities to set goals, solve problems, and make decisions for themselves, and giving them the opportunity to exercise their decision-making skills. This is what the studies have shown. But I think the most important reason to try to advance self-determination comes from Ryan's story. Now, I know Ryan well. Ryan is a very powerful self-advocate. He also has an intellectual disability, but he's been working in a job for 12 years. He has testified before the DC Council. He's been out in the community, volunteering. He's been choosing and planning his own services and supports, and he dreams about owning his own business. And his father described very powerfully what self-determination means to his family, because he's been supporting Ryan in making his own decisions. And he says, Ryan is a whole person. And Mr. King connects the decision-making process to what it means to be a whole person. If Ryan is forced to do something, he's destroying his selfness and being whole. And so that's the reason why Herbert wants to support Ryan in making his own decisions. And the story about Ryan, as well as his parents, Herbert and Susie, can be found at the link that's on this particular website, and it's a very powerful story. Ryan, too, speaks about what decision-making means to him and why it's important. And yet, when Ryan turned 18, he found himself speeding along the school-to-guardianship pipeline. Okay, his parents were told, in order to get services for him, they would need to become his guardian. They didn't think he needed one, Ryan didn't think he needed one, but they didn't know they had any other options because alternatives were not discussed with them. And so now Ryan has been under guardianship. They've been trying to use supported decision-making within the guardianship relationship, and they're working with Quality of Trust to get out from under the guardianship. But one of the difficulties is it's so much harder to get out from under guardianship than to avoid it in the first place using appropriate alternatives. You can learn more about his story at our website, supporteddecisionmaking.org. Guardianship has unfortunately been the default option for students with intellectual disabilities, despite all of this discussion we've had about how self-determination can improve people's life outcomes. And a survey was recently done, and it was found school personnel were the most frequent source of recommendations because, school personnel are on the front line of these kinds of conversations, given the transfer of rights. And so we really want school personnel to educate themselves that guardianship is not the only alternative for families. We still get a lot of calls from parents who say the school told them to get guardianship, despite the DC law and the implementation efforts of the DC Public Schools and now OSSE. But how do you do supported decision-making? There really isn't a one-size-fits-all method. It can include informal supports. It can include written agreements, which we're going to talk a little bit about, and circles of support like the IEP team. So there's lots of different ways of doing supported decision-making. It's really a paradigm rather than a process. However, these are some of the common considerations. You really need to start from a place of presuming capacity and the right of the person to make decisions. that they can take part in the decision-making process without removing their rights, and that they may need more assistance in making decision-making. They may need to have interpreter assistance or assistive technology, or more time in making decisions. They might need to have accommodations, and those are important considerations. And so in the educational context, we always tell people there are many ways to try to incorporate supporting decision-making into educational decisions for the adult student. Their supporters can help the adult student sign a FERPA release form, and that would allow the information to be able to flow between the supporters and the school, so that the supporters have the information they know to help advise and educate the student on decision-making and how to make the decision and the decision that they're facing right now. So that's one easy way to allow the information to flow. All schools have this FERPA release form, and it can be used to try to document supported decision-making arrangements, as I'm going to show you shortly in the context of DC Public Schools. There are other ways that parents, too, can let the school know that they want to be invited to all IEP team meetings. Regulations already require invitations to go out to parents, even when the student turns 18. But I also encourage educators to think of their role in trying to help the student get ready for meetings. How do you make an IEP meeting, team meeting friendly? How do you allow students to try to be supported in expressing what they want at their IEP team meeting, what they want to be their goals, what they think about their goals? I also think it's important to think of IEP team meetings as not this kind of finite thing that the student can't have a break if they're overwhelmed to talk to their parents separately. Student has rights, and they should be able to take papers home before they sign them, and they should be supported to lead their own IEP team meeting. Unfortunately, I had a case where a student I was working with, the first time he'd ever been to an IEP team meeting was when he turned 18. And I think that's far too late. He was very intimidated by the process. He didn't even know what to expect. He just knew that beforehand, educators had been meeting with his parents to make decisions for him. And so he was very scared about going to his first IEP team meeting. And I wish I'd met him earlier, because I would have encouraged his participation earlier on, when he was 14, when he was 15, when he was 16, even earlier. So I really do think we need to think carefully about how we can do supported decision-making in education, because it's very much possible, and we should be doing it since it's a special educational best practice. DCPS can serve as a great example for charter schools, because they're already in the process of implementing supported decision-making. They've created transfer of rights guidelines that you can see on their website, and a supported decision-making form that is really a fancy FERPA form that just the student identifies the supporters that they want to be involved in their decision-making, and they allow information to flow to those supporters. This is what the form looks like. So you can see very easily to be modified using your own charter school's FERPA form to work for you, and to allow your students to have a documented supported decision-making arrangement. Let's remember, supported decision-making, again, isn't only for students who have intellectual disabilities. It's also for students who have any form of disability. Students who have turned 18 and who want their parents' support and continued support in their educational planning. You could have a physical disability. You could have a mental health disability. Those students can also benefit from supported decision-making, just as we all did when we were 18. I always say, as I said before, start early. That kind of caution story I told you about, that young man who met with me and never been to an IEP team meeting, and so was so intimidated by the process. Let's include students in IEP meetings, starting in elementary school. DCPS has actually started certain supported decision-making curriculums beginning in pre-K, which is excellent. And I think thinking about decision-making and rights in that way is an important kind of tool to realize that decision-making is related to education. It should be incorporated into the IEP. There should be specific goals that are related to them. There should be, instead of saying students are going to, that the student won't be late for class, use I statements. I am going to manage my time better and be not late to class 3 out of 5 times. There can be ways in which you use I statements to really make it about self-determination. And we have some great examples on our website at www.supporteddecisionmaking.org. It really promotes student involvement and accountability. It treats students as though they matter and that their opinion matters, and it also prepares them for when they will have the rights to exercise their own decisions. I also think it's important to periodically evaluate a student's self-determination skills and decision-making, because you need to think about decision-making as part of special education and educational goals, and you want to be able to tailor goals to be both individualized to the student, but also progressive over time to challenge the student to be able to build that decision-making muscle I talked about. Now, that's supported decision-making. What is a power of attorney? That's another alternative. And a power of attorney is a legal paper where an adult, in this case the adult student, agrees that someone else will make the decisions for him or her under certain circumstances and in certain areas of his or her life. So there can be things called educational powers of attorney, where students can allow their parents to continue to make decisions for them. How is it different from guardianship then? Well, you don't have to go to court to get it. Okay, the student decides what power to give away and who gets it, not a court. And the student can cancel the POA. So the student still has that decision-making right to say if you can make a power of attorney, you can break a power of attorney. And so they can revoke or cancel the power of attorney if they decide they want to continue to make their own decisions, for example, using supported decision-making. So that's what a power of attorney is. And they are frequently used in the educational context. But let's think about the continuum of capacity I talked about earlier. There can be compare an educational decision that's very complicated, like deciding whether or not to formally challenge a decision the school has made. That can be a very intimidating kind of decision to make, and there can be pros and cons and costs associated with that decision. Now compare that to an educational power of attorney, where you're not making that complicated decision. You might not be able to make that complicated decision, even with support, but you do have the capacity to say, I don't know that, but I trust my mom to make that decision for me. That's a lesser degree of capacity, and that's what's required for a power of attorney. And powers of attorney you shouldn't think of them as those big complicated documents that you or I would sign. They can be very simple 2 or 3 page documents that follow the law that are very simple and plain language for the student to understand. The other alternative in the educational context is these rules that are coming out from OSSE, the Office of State Superintendent of Education, is going to establish an alternative procedure for adults who cannot provide informed consent, even with support. Okay, there's going to be a certification process in which 2 professionals make determinations the student can't make those kinds of decisions, and then OSSE would be able to appoint the parent or family member to make the decisions for the student. The student will always have the opportunity to challenge that determination under the law. And you can see what the current notice says. They just published that notice on May 13th, and so it's still in draft form. You can comment on it. I think the deadline for commenting is today, actually. And you can take a look at the kinds of certification OSSE is thinking about, even though it's not final yet, so not in effect yet. So I'm running out of time, but I did want to kind of say there are also alternatives in healthcare and finances. Some parents may have concerns about those particular kinds of issues, and these talk a little bit about how you can do in both the healthcare and finance context. We really want people to think of everyone having a right to make choices and to use the tools that are in our supported decisionmaking.org website. We have one, for example, that allows people to help brainstorm around supported decision-making, and that's a very useful tool. But I also want you to know that we're here to help. Quality Trust is here to help. And we can have those kinds of complicated conversations with families about the alternatives before they think they have to go to guardianship. We are funded to do that and to provide that kind of free service to DC residents right now. We can also provide free training on the very issues we talked about today for parent groups, students with disabilities, educators, school transition coordinators, so people know that guardianship isn't the only answer for students with disabilities. And we also have legal and lay advocacy resources for students who are planning transition from school to adults. So people who were in Ryan's kinds of situation, who was planning for the future, we weren't there to be able to provide him with that assistance, but we would have been if we could have been. So I do want you people to think of us as a resource you can refer students to and families to if they raise questions. The DCPS Transfer of Rights guidelines actually mention us as a resource. So if people have questions and you have to focus on the educational aspects of things, that it goes beyond that, you can refer them to Quality Trust, and we'd be happy to try to see if we can help the student in collaboration with the parents explore alternatives to guardianship. I wanted to include my contact information as well so that you can see there are lots of resources out there. And you can contact me if you have any kinds of questions or pass on my information to families you may be working with that have questions about transfer of rights that go beyond what an IEP team can provide them. So we only have about 5 more minutes for questions, I think, but I'm happy to answer any questions that the audience may have.
Thank you so much, Morgan. This is Julie. I've been monitoring the chat and the question box, and I think your presentation was so thorough that no one has any questions, although I am sure there will be follow-up, and I want to thank you so much for doing the webinar, but also providing us with all of these great links to resources that can help us learn more. I'll leave it open for another minute for questions, but if nothing comes in, we will end the webinar, and then I'm sure this is, just the first step in the partnership, and I know our schools are going to be very excited to partner themselves with Quality Trust. So thank you again so much for doing this, and I think last call for questions. I don't see anything coming, but I'm sure that they will soon. So I will end the webinar, and thank you again, Morgan.
Thank you.